All right, the attorney appeared on behalf of the people.
Stephanie Cannon on behalf.
Go ahead.
Stephanie Cannon on behalf of Mr. Dennis, who is appeared to our right. Mr. Dennis, could you please state your name for the record?
Harold L. Dennis.
Thank you. Tanaza, you say nothing all morning. Nothing. Nothing. You sat there quietly, finally behaving yourself. And then when I call the case, you are disruptive to Miss Curry, so she is delayed. You're going to sit down now, aren't you? Thank you. All right. What are we doing on this, man?
Your Honor, I did submit a request for an adjournment for 3 weeks. It's my understanding prosecutor is not objecting.
That's correct.
All right. Probable cause conference will be adjourned March 20th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Alan,
So
people watching. I swear I will tether her. Court calls the case, people versus Mark Capaldi.
Ashley Moen, Assistant Public Defender, appearing on behalf of Mr. Claude.
Mark Capaldi.
We are requesting an adjournment. We have not been able to go over the media discovery and for plea negotiations.
Probable cause conference March 13th, 2025, 9 a.m. Bond continued.
May I address bond? Please.
Sure.
Mr. Capaldi is he's a sole caregiver of his 77-year-old grandmother who was just released from the ICU. He maintains their family home and farm. He's self-employed. He currently has a $25,000 bond. We're respectfully requesting an opportunity to post 10%.
Any response from the people?
Your Honor, the people will be opposed to any plea reduction in this case. As the court can see from the charging documents, this is an arson matter. In this case, the troopers responded out to a neighbor of the defendant who had called the police after being informed that there was a bale of hay on fire in front of his house. And it's one of those very large bales that the court may be familiar with that are used in farming and for the feeding of animals. The troopers arrived on scene and were able to follow tire tracks from the scene to the defendant's home and found broken pieces of wood at the scene where the fire was that in their mind matched up to the trailer that there was hay bales on at the defendant's home. So I do believe the likelihood of conviction is very high in this case. The court is familiar with the incredibly dangerous nature of arson in and of itself. And I also let defense counsel know that there's a warrant request pending for an OUID for this defendant as well.
Anything else?
No.
Motion for bond reduction denied. Bond will continue. Thank you. Court does call the case. People versus Eric Fowler.
Ashley Lonnie for the people.
And Matt Camp, we have Mr. Fowler, who is approaching. Say your name for the record.
Eric Fowler. What are we doing?
We are asking for a 2-week adjournment awaiting body cam media discovery, Your Honor.
That's correct, Your Honor. Mr. Brown emailed me about that. We're working on it.
Probable cause conference March 13th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor.
Cross case, people versus Cameron Curtis.
on behalf of Mr. Curtis, who is appearing to our right. Mr. Curtis, could you please state your name for the record?
Cameron Curtis.
He's waiving exam.
Yes, sir.
Sir, is that a correct statement? You're waiving preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on all 3 counts. Ms. Cannon.
I would waive it, the reading of the information, Your Honor. We waived reading of information and stand mute.
Defendant every way, former reading, standing mute. Court will enter a not guilty plea as to all 3 charges. Pretrial in this matter will be set for
March 10th at 1:30 p.m. with Judge Hamud.
March 10th, 2025, 1:30, Judge Hamud. Bond continue. Thank you.
Sorry.
Court calls case People versus Durantu Francis.
Pass along to the people.
And good morning, Your Honor. Assistant Public Defender Chinazai Carey on behalf of Mr. Rantu Francis, who is appearing via Zoom, Your Honor. Ms. Francis, state your name for the record, please.
Durantu Francis.
Your Honor, we're requesting an adjournment in this matter. We're still in the midst of negotiations.
Welcome.
Thank you.
Morning to you.
Good morning to
Nice
you
to
as
hear
well.
from you.
Thank you.
Not true. You sounded good, didn't it?
I like to believe it.
Our cross conference will be adjourned March 13th,
Thank you. Your Honor.
2025. 9 a.m. Bond continue. Court calls case People versus Emmett. Is it Aaron Reich?
Yes, Your Honor, it is.
No, he's
Children?
busy. He's busy talking to them.
Assistant Public Defender Jay Bellinger on behalf of Mr. Aaron Reich, who appears by my side. Mr. Aaron Reich, can you please state your name for the record?
Amit Ehrenreich.
All right.
And Your Honor, we are asking for a preliminary examination date.
Discovery is complete.
Discovery is complete.
People have their witnesses available the 11th.
That should be fine.
Preliminary examination in person, March 11th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Bond will continue.
Thank you. We'll make sure we're.
Mr. Bellinger, could you briefly approach on a separate matter?
Yes, Your Honor.
I got Polly. Court calls the case People versus Sincere Godwin.
Mr. Public Defender Natalie Pate on behalf of Mr. Godwin, who should be present via Zoom. Sir, if you're present, can you please unmute and state your name?
Well, that's not gonna happen.
So, Your Honor, I'm well, maybe I don't have an explanation for his failure to appear. The number I had for him was his mother's. I did speak to her yesterday, and she was to have him call me back. I did not hear from him. I did provide his mother with the Zoom link, and I did expect him to be present. For the record, I'd request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Autumn. Is it Fonte?
Pass along to the people.
Good morning, Your Honor. Assistant Public Defender Fellow Alexis Zerk on behalf of Ms. Fonte, who's approaching.
Wow. It's been a minute. Your name?
Autumn Fonte.
Thank you. I have to be a plea for whichever we're doing.
Yes, ma'am.
Plea form indicates that defendant will be pleading guilty to the charge of use of a controlled substance, that being ketamine, the 1-year offense. Upon her successful plea of guilty to that charge, count 1 would be dismissed. There's an agreement, no delayed, no deferred, no 7-4-11.
That's Honor sending in the plea, Your Honor.
May I have her sworn?
Raise your right hand. Right hand.
Sorry,
You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Autumn Rose Fonte.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of the use of a controlled substance. Is that correct?
Correct.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while you're pleading, I'm taking your guilty plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Right.
Okay. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty,
You understand that by pleading guilty, you'll not have a trial of any kind.
right?
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Right.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your
Has
Honor.
anybody promised you anything other than what's been stated here today to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily of your own free will and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
June 10, 2023, at the location of 5 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have ketamine in your possession?
Yes, Your Honor.
Did you have any prescription or right to use that drug?
That's fine.
All right. And you did use it?
Yes.
And you knew what you were using was ketamine?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report, as well as screening and assessment, are ordered at 14A2 District Court. Sentencing in this matter will be
March 12th at 11 a.m. for Judge Barr.
March 12, 2025, 11 a.m. Judge Barr.
And Your
Bond.
Honor, if I can briefly address bond.
He hasn't been here in like ages. He just like barges in and wants to start doing stuff. Go ahead.
Your Honor, Ms. Font does recognize that she failed to appear back in October. She had been in constant communication with the Public Defender's Office, and it was a miscommunication. Her test results did not get over to community corrections in time to show that she was in fact testing. Since then, she's run into some housing troubles. She's currently in subsidized housing. She's at risk of losing subsidized housing if she remains incarcerated. If she were to be released on a personal recognizance bond, she has plans to stay in the area. She has some friends she can stay with. She believes she'll be able to test now because it is cheaper to test at community corrections than it was to test up in Traverse City. And that was the main reason and burden of her not being able to test. She also has some health concerns that she wishes to get out to be able to go to doctors and address that. She explained to me she has an infection in her chest that needs to get looked at. And and she is looking back up with CMH. So she's planning on staying around to get the services that she needs with CMH as well. And if the court is concerned about her appearing at future court dates, she'd be willing to go on a GPS tether.
Response.
In large part, I trust the court and just leave it in your discussion. The only part I wasn't clear on was if she resides in Traverse City and is at risk of losing her housing in Traverse City, why would she stay local? She said she could stay local with friends. So that was the only part that didn't really make sense.
It did
But
make sense.
in general, she has pledged with misdemeanor, so I'll leave it in your discretion.
Your Honor, so she would stay around here to resolve this case, and then she'll be able to have contact with her son who resides at the apartment with her, and she will be able to help him via the phone to get the situation rectified. She has a caseworker working on the case as well, so she'll be able to maintain contact with him. So that would assist in the housing situation as well.
I still not understanding the housing situation.
She has unpaid rent and she has a caseworker who's working on it, but he was not able to contact her because she was incarcerated. So if she is out and released, he will be able to talk to her, talk to her son, and get a situation rectified.
That typically is not how it works, especially if there's somebody else at the unit. They can still deal with part of that. If they know she's in custody, they can get through to contact her if they need to. We have to do it all the time in our house.
Your Honor, I'm just going based off of what.
I know.
Communicated it to me.
Oh, I know. I mean, I realize that. Motion for bond reduction tonight. Bond will continue. Thank you. Court calls case People versus Benjamin Detlefs.
Dr. Lonnie.
Stephanie Can on behalf of Mr. Detlef. He should be on Zoom, Your Honor.
Detlefs.
Your Honor, it does.
Where?
He's not here.
He's in the jail, Your Honor, but he is level 1. Last time I checked, he was.
Oh, he was
very
down in
excited.
the jail.
He must have dropped.
They dropped.
I'll take it
Okay.
back, yeah.
watch them again.
All right. Court does call the case, People versus Joel Helm Mormon.
Stephanie Head on behalf of Mr. Held Mormon.
State your name. Joel Helm Mormon. Thank you.
Your Honor, my client has asked for a preliminary exam to be set. I've gone over discovery with him. We do believe it is complete.
You will have their witnesses available the 11th. Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Valvo. Bond will continue.
Thank you.
Court calls case People versus Charles Carker.
Yeah, okay.
Good morning, Your Honor. May it please this honorable court, David Burgess on behalf of Charles Carker, standing to my right. Your Honor, I recently received this appointment. I still need to get discovery and review of my client, so I'm asking for a adjournment of 2 weeks.
Your name?
Charles Carker.
Probable cause conference will be adjourned March 13th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Micah Jones.
Assistant Public Defender Natalie Pate on behalf of Mr. Jones.
They're not.
He is in custody.
Everybody else in custody? Micah Jones.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jones, who is approaching. State your name for the record, sir.
Michael Jones.
Thank you.
Thank you, Your Honor. I have discussed this matter with the people as well as Mr. Jones. We're respectfully requesting a brief adjournment to receive the video discovery. I do believe, frankly, our office might have received it already this morning. So
March 13th,
Thank you, Your Honor.
2025, 9 a.m. Bond will continue. Court calls case People versus Marquise Hankey.
And is it on behalf of the people, Your Honor?
Good morning, Your Honor. Attorney Kevin Basant, P 71061 on behalf of Mr. Marquis Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey. All right.
And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, appropriate.
Adjourned matter March 13th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say, but.
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail before he got out.
Do we have that?
No, we do not.
And you're aware of this?
I am, Judge.
And I also wanted to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't do nothing, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defendant says, y'all been talking, right? He says, no, I've only been talking to Keita, who's the victim. He says, can't say that name on the phone, because she's my things. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call.
and they're talking. And I also have concerns that he'd be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well at a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just
is
so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would.
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSC fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge, community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. There was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have this bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, all right, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Kia, who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
He's playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with the bond at that point. But right now, he's remanded.
Thank you, Judge.